Chapter 9. Peculiar Jurisdictions. If any doubt should be entertained whether the 92d and 93d canons are applicable only to the peculiars belonging to the Archbishop of Canterbury, or whether they may extend over other peculiars, it will be necessary to inquire into the nature of peculiar jurisdictions, and I. What is a peculiar and exempt jurisdiction? 2. What jurisdictions come under the denomination of a peculiar and exempt jurisdiction? 3. What jurisdictions are not exempt from, but subordinate to, the bishop of the diocese? 4. What peculiars are subject to the prerogative court, by reason of a person having, at the time of his death, goods or good debts to the value of 5 litres, in another peculiar or diocese than in that wherein he died? I. What is a peculiar and exempt jurisdiction? Aleph, in his Paragon Juris Canonici Anglicani, gives the following description of peculiars, in p. 417. There are many peculiar or exempt jurisdictions in England, to the great inconvenience and hardship of the subject, but these are not called exempt jurisdictions, because they are under no ordinary, but because they are not under the ordinary of the diocese, but of one of their own. In p. 419 of the same work, he adds, all such parishes and places which we call peculiars, are exempted from the jurisdiction of the proper ordinary of the diocese where they lie, not only in respect to the probates of wills, and granting letters of administration which are matters of voluntary jurisdiction, and the like, but also exempt from the cognizance of all matters of contentious jurisdiction, and whenever they have reason to appeal a cause from their own ordinary, it is to the king in his high court of chancery, and not to the bishop of the diocese, or the provincial archbishop. A peculiar prima facie is to be understood of him that has jurisdiction co-ordinate with the bishop. 6 Mod. Rep. 308. In the case of Parham v. Templar, 3 Philimoras Reports, 248, Sir John Nicol, after taking a general review of the nature of peculiars, says, the general result of this, is, that a peculiar is not subordinate to, but coordinate with the jurisdiction of the bishop. From these authorities, it is to be collected that a peculiar and exempt jurisdiction is not subordinate to, but co-ordinate with the jurisdiction of the bishop of the diocese in which it is situated, and that the ecclesiastical jurisdiction there is exercised solely by the dean and chapter, prebendary, and see, or their respective officers, without being subject to the control and visitation of the bishop, and without having their appeal to him. 2. What jurisdictions come under the denomination of a peculiar and exempt jurisdiction? First, of these peculiar and exempt jurisdictions, there are several sorts, viz., royal peculiars, which are the king's free chapels, and those are exempt from any jurisdiction but the king's, and, therefore, such may be resigned into the king's hands as their proper ordinary, either by ancient privilege or inherent right. But how far resignation may be made into the king's hands, as supreme ordinary, as in Goodman's case, it is not here a place to examine. 2d. Archbishops had, and have still, their peculiars, which are not only in the neighbouring dioceses, but dispersed up and down in remoter places, for it appears by Eadmerus, that wherever the archbishop had an estate belonging to him, he had the sole jurisdiction as ordinary. 3d. Deans and chapters had likewise their peculiars, which are places wherein, by ancient composition, the bishops have parted with their jurisdiction as ordinaries to those societies, whose right was not original, but derived from the bishop, and when the composition is lost it depends upon prescription, as in the deans and chapters of Street, Paul and Lichfield, which are mentioned in the year books. And lastly, monasteries had also their peculiars belonging to them. Aleph's Paragon, 418. I have said before, that deans and chapters have their peculiars by ancient composition from the bishops, as ordinaries to those bodies of men. But where these compositions are lost, and there has been a constant usage, time out of mind, for these societies to grant institutions, they may in such cases maintain their right by prescription, and this is done by the dean and chapter of Street Paul's in London, and by the dean and chapters of York and Lichfield. Aleph, 418. There are royal peculiars and archbishop's peculiars. The king's chapel is a royal peculiar, exempted from all spiritual jurisdiction, and referred to them. mediate government of the king. There are also some peculiar ecclesiastical jurisdictions belonging to the king, which formerly appertained to monasteries and religious houses. It is an ancient privilege of the See of Canterbury, that wherever any manors or advowsons belong to it, they forthwith become exempt from the ordinary, and are reputed peculiars of that see, not because they are under no ordinary, but because they are not under the ordinary of the diocese, and see. For the jurisdiction thereof is annexed to the Court of Arches, and the judge thereof may originally cite to these peculiars of the Archbishop. Wood's Institute, 530. The several peculiars which are also exempt jurisdictions are, first, the King's peculiars, 2d, the Archbishop's peculiars, 3d, the peculiars of some deans and chapters, as of St. Paul's, of the Dean and Chapter of Salisbury, of the Dean and Chapter of Lichfield, and c. Fourth, peculiars of monasteries, but as the exemption of each Dean and Chapter from the jurisdiction of the ordinary must depend upon the compositions entered into with their respective bishops, or in cases where such compositions have been lost, upon the usage, as proof of the composition, it is presumed that no general rule can be laid down upon the subject, either that the jurisdictions of deans and chapters are, or are not, peculiars and exempt from the ordinary of their respective dioceses, but that some deans and chapters exercise jurisdictions subordinate to the bishop will appear by the third division of the subject. 3. What jurisdictions are not exempt from, but subordinate to, the bishop of the diocese? There are some peculiars which belong to deans and chapters, or a prebendary, exempted from the archdeacon only. They are derived from the bishop, of ancient composition, and may be visited by the bishop in his primary or triennial visitations. In the meantime the official of the dean and chapter, or prebendary, is the judge, and from hence the appeal lies to the bishop of the diocese. Wood, 530. Appeal lieth from other peculiar courts to the king in chancery. Stat. 25 Hen. 8. C. 19. The Dean and Chapter of St. Paul's have a peculiar jurisdiction, and the Dean and Chapter of Salisbury have a large peculiar within that diocese, so have the Dean and Chapter of Lichfield, and c. 2 Nelson's a break. 1240. 1241. If a peculiar be subordinate to the bishop, then he cannot refer a cause to the archbishop, but to the immediate ordinary, as an archdeacon or commissary must do. Otherwise it is, if the peculiar have his immediate resort to the archbishop. Hob. 186. Holt, C.J., says, there are three sets of peculiars. The first is when archdeacons, and c. have a peculiar within the diocese, and subject to the jurisdiction of the ordinary. Second, when one has a peculiar not subject to the ordinary, but to the archbishop. And the third is when one has a peculiar, subject neither to the ordinary nor to the archbishop, as there are some. And though the dean of Sarum is to some purposes subject to the jurisdiction of the bishop, yet as to this peculiar, it is all one, as if it was a stranger, and it is not under the jurisdiction of the bishop of Sarum, more than of the bishop of London. Skinner's Reports, 589. All peculiars are not inferior to the ordinary of the diocese in which they are, and such as are not cannot transmit any cause to the ordinary, and such transmitting must always be to the immediate superior. The Dean and Chapter of Salisbury have a large peculiar within the limits of the diocese, but as much out of the jurisdiction of the Diocese of Sarum as the Diocese of London is. The peculiar jurisdiction of an archdeacon is not properly a peculiar, but a subordinate jurisdiction. Lord C.H. J. Holt, 6 Mod. Rep. 308. Vide Hob. 185, 186. From the introductory words in the case last cited, it may be presumed, that it was the opinion of Lord Holt, that the majority of peculiars are subject to the jurisdiction of the diocesan. In Parum Templar, 3 Phil. 246, there is a third description of peculiars, which are still subject to the bishop's visitation, and being so, are still liable to his superintendence and jurisdiction. Wood in his Institute mentions these. He says, these the bishop visits at his first and triennial visitations. Here the appeal lies from the peculiar to the diocesan, but the right of appeal and the right of visitation seem almost necessarily to go together. Per Sir John Nicol. In the case of Bear and Biles v. Jacob, Hilary Term, 1829, 2 Haggardes Reports, 257, the main question related to the jurisdiction of the subdean of Sarum. Sir John Nicol says, the first point, which hardly admits of any question, either of fact or law, has been but little pressed in argument. The instrument of appointment of the subdean has been exhibited, and is merely subordinate and archidiaconal. The bishop visits and inhibits. During his visitation the subdean's jurisdiction is wholly suspended, and is merged in and exercised by the bishop as in ordinary archdeaconries. This jurisdiction of the subdean of Sarum is well ascertained, and has been made more public by the return to Parliament, in the last session, of courts exercising ecclesiastical jurisdiction. In the Diocese of Sarum, it is stated, the Bishop of Sarum, by his Chancellor, exercises the authority of granting probates and administrations in the subdeanery of Sarum, during the bishop's triennial visitation for 6 months, only containing 5 parishes. The subdean of Sarum exercises there, above, authority, except for 6 months every 3rd year as aforesaid. This return confirms what appears from the instruments of appeal, and from the appointment of the subdean, that he is appointed by the diocesan, and has a mere subordinate jurisdiction, and his jurisdiction being subordinate, and not peculiar and exempt. No doubt in common cases the appeal lies to the diocesan, and not per saltum to the archbishop. Although Lord Holt, in the case of Johnson and Lee, called the jurisdiction of archdeacons, and c. peculiars, within the diocese, and subject to the jurisdiction of the ordinary, yet in the case, in 6 Mod. Report, his lordship stated that the jurisdiction of an archdeacon is not properly a peculiar, but a subordinate jurisdiction. The case of Bear and Biles v. Jacob was determined upon the same principle, and has rendered clear the distinction, that those jurisdictions only are peculiars which are exempt from the bishop of the diocese in which they lie, and that the jurisdictions of deans and chapters, prebendaries and archdeacons, which are subject to the visitation of the bishop, are inhibited from exercising jurisdiction during such visitation, and have their appeal to his consistorial court, are subordinate jurisdictions, and not peculiars. For, what peculiars are subject to the jurisdiction of the prerogative court, by reason of a person having at the time of his death goods, or good debts, to the value of 51. In another such peculiar, or in another diocese. It is laid down in the case of Parum and Templar, that in the cases of wills and administrations, where there are bona notabilia, peculiars are considered as separate jurisdictions, and not as being part of the diocese, for if there are bona notabilia in a diocese under the ordinary jurisdiction of the bishop, and also in a peculiar in that diocese, or in 2 peculiars situated within the same diocese, in such case the probate belongs to the archbishop. It is so expressly laid down by Gibson, Swinburne, and in a case in Sidofin, and it is declared by those authorities, that in such case probate shall be granted, not by the diocesan, but by the archbishop, because such peculiars are exempt from the jurisdiction of the diocesan. The distinguishing feature, therefore, by which peculiars may be known to be subject to the prerogative court, by reason of their being bona notabilia, is that such jurisdictions are exempt from the control and superintendence of the bishop of the diocese, in which they are situated, or to which they belong, and the evidence of their exemption consists in the fact of their not being subject to the bishop's visitation, and by their not having their appeal to him. On the other hand, wherever ecclesiastical jurisdictions are periodically inhibited by the bishop, and are subject to his visitation, and have their appeal to him, they are not peculiar jurisdictions, but subordinate to the bishop, and not being peculiars, are not subject to the jurisdiction of the prerogative court, either in cases of persons dying in them, and having at their deaths goods in any similar jurisdiction, or in the diocese in which such jurisdictions are situated, or in cases where the parties die in the diocese, in which these jurisdictions are situate, and have, at the time of their deaths, goods to the value of 51. In any such jurisdiction or jurisdictions,